final part of this 5-part series, we're talking about the other big D, divorce, and how its impact on death and real estate can truly wreak havoc on the loved ones you leave behind. This is definitely a video you don't want to miss. Let's take a listen.
So besides death, the other D word that many people experience throughout their lives, divorce. So nowadays when spouses purchase property together and they end up having a family, children, 1, 2, 3, etc., divorce happens somewhere down the line. And usually somebody, whether they end up selling the property, which we've had to deal with in our brokerage, or one of them keeps the property. The paperwork doesn't get filled out as far as what happens. One of the spouses that keeps the house remarries, and that person has children, or they start a new family. What are some of the situations that could arise for the children of the first family?
Let's start with the concept that you have to look at how things were titled to begin with. So spouses who have titled the property in tenancy by the entirities, which is a legal fiction that says that both spouses have a 100% interest in the property. Legal fiction because 100% is 100%. Mm-hmm. But if each of the parties has 100%, creditors can't impact the other spouse's interest in the property. They can only impact the interest of the person who they have a claim against. Once people divorce, once they separate, in fact, the elements that are necessary for a tenancy by the entirities dissolves. You have to be married, residing in the same household, and not separated. So if any of those elements is missing, because you can reside in the same household and still be separated, and you can be divorced, and that would sever the tenancy by the entirities and make it a tenancy in common. If there's a joint tenancy, say you never got to tenancy by the entirities, there's a joint tenancy, and there's no severing of the joint tenancy, then what happens is that you wind up with, if a spouse dies, the other person winds up with 100% interest. If the parties are in a joint tenancy and one of the spouses decides that they're going to lien their property, they've now dissolved the joint tenancy and it's now a tenancy in common. So you're starting from the premise of what's the tenancy, what's the ownership of this property? And if that hasn't been dealt with in the divorce, you may be dealing with it in death, because if a joint tenancy will automatically transfer the property to the other spouse if they haven't dealt with it in the divorce. Mm-hmm. If it's dealt with in the divorce and nobody's done anything about the transfer, you may wind up with another problem. We had a case recently where the court ordered the property to be divided at a time in the future. The wife was going to continue living in the property. The husband was to quitclaim his interest in the property, but he wanted to make sure he got paid the amount that he was entitled to, and so he put a lien against the property. Then we recorded the quitclaim deed, because each party got what they were supposed to get. In the event of death, the wife's heirs are entitled to inherit, but the husband's heirs are entitled to the money from the lien against the property. It's really critical to make sure that in order to determine who inherits, that the titling has been done properly. And sometimes it's a fight in the divorce. Sometimes it's a fight after the divorce, especially if the attorneys for the divorcing parties haven't finished that documentation. And many times, one of the parties isn't represented by counsel. So the issues of how that titling occurs can be that much more complicated, because somebody who isn't represented by an attorney wouldn't know that that's an issue that they have to resolve. So it's important to know how title is held after divorce, in order to know who's going to inherit and how that distribution is going to occur.
And, one of the issues you'd want to avoid is the children from the first marriage not having a conflict with, a spouse, once they've remarried, because there could be problems that could potentially arise from there.
Oh, and that certainly brings to mind a problem that had happened with a property where the property had been was intended to be put into a trust, and the deed was never recorded. So the man of the couple owned the property. He had a 1/2 interest. The woman owned a 1/2 interest. She was selling the property, thought the property was in the land trust and she had the right to make the sale, and she didn't because the deed had never transferred. And the heirs didn't really care what happened with their property. They had gotten so much money from Dad, from his estate beforehand, that they were just not at all helpful. It took us months to get closed because we had this issue on title that we didn't have clarified because the transfers that needed to be made weren't made. Goes back to your estate planning, goes back to your, there may have been some malpractice in there, but we don't even know who to look at for that kind of stuff.
And when you're dealing with months of attorneys working on something, that equals more time, more fees,
Right,
and then
exactly.
just taps into the estate.
Exactly.
If you found this video to be informative and helpful, make sure you show some love and hit the like button. Be sure to subscribe and click that bell so you can catch all our future videos. If there's something that you feel we didn't cover in this video, or you have another real estate related question, please let us know, reach out, and we'll be sure to make a video about it. Thank you so much for your time. We appreciate you watching, and we'll see you next time.